A lot of my clients have recently retired and they come to see me to update their will and estate plan. An overwhelming concern for a lot of retirees is that they've worked their entire life to build a nest egg which they intend to retire on, and then when they pass away, leave a legacy for their children. That money is in fact protected for the intended purpose, and that is for their children to have a comfortable life and not wasted by way of family law breakdown or lose the money to creditors. It is really important for a retiree to have an up-to-date will and estate plan. This will really ensure that your assets are passed to who you want, when you want, and more particularly, it will prevent any chance of there being a claim made against your estate or any squabbling after you pass away. By putting the plans in place now, it really eliminates a lot of the risk that you would have if no plan was put in place at all. A lot of retirees are concerned that their children are in relationships where there's a risk that that relationship may break down in the future. What they want to ensure is that their inheritance that their children will receive will not form part of a family law dispute, and we can provide a mechanism within the actual will to try and protect that money and quarantine it away from any family law dispute. There's a greater need for a retiree to have a considered will and estate plan where they have complex family situations. Now, there's many examples of this. Some are that if there's a child that is estranged, or they're a part of a blended family where there's a risk that there may be a dispute or conflict after one or both of the parents pass away. By having a will and estate plan, we can put actions in place to ensure that there is little chance of litigation and little chance of dispute, which could cost tens of thousands of dollars to resolve. Another issue that retirees have in respect to their will and estate plan is protecting their money from the children themselves. That is, if they can't handle a big sum of money because they would waste it, or they've got some issues with dependency such as drug dependency or gambling, there's certainly mechanisms that you can put in place to protect that money and for the money to be used for its intended purpose. Retirees are also concerned if their child is in a high-risk profession, and that is a profession where there's likelihood that they're going to be sued. Again, that this money that they've received by way of inheritance is protected so that any creditor cannot come and claim some of that money. Many retirees have assets in their own individual names, together with any assets in companies or trusts and assets in superannuation. From a wills and estate planning point of view, it is really important that clients understand that not all your assets will form part of your will. That is, only assets in your own individual name will be governed by the terms of your will. So any asset in any trust, any company or superannuation is separate to that. An effective will and estate plan will not only have a properly drafted will, but also make sure that the company and trust is structured in a way that the most appropriate people will control those entities in the event of incapacity or death. The whole will and estate planning process is not just having a will, but also having those other entities and superannuation structured in a way that will give effect to your total estate plan. If you want peace of mind, knowing that your estate is protected and will go to who you want at the most relevant time, please contact us for a free initial consultation so we can best advise how to protect your estate.